ago, he indicated that he expected to be about 15 minutes, but I believe there are some other issues we can take up in the interim.
All right.
Your Honors, we had addressed earlier, we have one witness that's here that's would be offering with respect to the turbulent and aggressive conduct of Mr. Chapman in the past that I'm assuming the court wants to take out of the presence of the jury. We have that witness here. The second witness, as we indicated earlier, refuses to come, and we'd be asking the court to issue a show cause for him.
Carter witness. Got another name.
Let me get that, Judge.
Not one that's so called, but the one that's here.
Oh, the one that's here is Officer Tiller.
All right. Carter.
What is it? It's a map.
Coming down. Now you can put it right there. We'll turn it there one step up. Now, you can put it right there, but just flip it so it won't be standing up. Right, can't steer. All right.
Thank you. Good afternoon, sir. Could you tell us your name, please?
Officer Tiller, Chesterfield County Police Department.
You have to speak a little bit louder than that.
Officer Tiller, Chesterfield County Police Department.
And officer, how long have you been employed in Chesterfield County Police Department?
7 years.
All right. Directing your attention back to the 14th of April, I believe, of 2014. Is that correct date?
Yes, sir.
All right. Were you on duty on that day?
Yes, sir.
And what was your duty assignment on that day?
Patrol officer B305.
And did you receive a call to respond to a home?
I received a call for a disturbance at a group home inside my beat.
All right. And as a result of that call, what did you do?
Once I arrived on scene, well, actually prior to arriving on scene, I got through dispatch that it became physical, so I increased my speed, got there, and on arrival came in contact with Mr. Chapman.
All right. Was there another person that was there that was in contact with Mr. Chapman as well?
Yes, sir. His counselor, Mr. Khan.
Okay. And you have not seen him here today? Mr. Connick?
No, sir. Actually, I haven't seen him since that incident.
All right. And when you entered, were you in uniform?
Yes, sir.
Marked police car?
Yes, sir.
And when you entered into the group home, what did you see and what did you do?
Once I entered, I encountered Mr. Connick restraining Mr. Chapman on the floor. Mr. Chapman was on his belly. Mr. Connick was on top of him, and they were kind of tussling.
Okay. And what actions did you see on the part of Mr. Chapman?
He was just yelling explicits.
Expletives?
Yes, sir.
All right. He was cursing.
Yes, sir.
And what, from a physical standpoint, what did you see Mr. Chapman do?
He was actually just trying to get away from Mr. Connick. At that time, for everybody's safety, I detained Mr. Chapman with cuffs.
And Mr. did you learn of the relationship between the two parties, Mr. Chapman and Mr. Connick?
He was his counselor.
Okay. As a result of that incident, you took Mr. Chapman into custody?
I did for assault.
Right. As a result of that, was a warrant taken out for him for, or a petition, I should say?
It was a juvenile petition.
And Your Honor, just in terms of the record that was taken, the petition was taken out, and on the Trying to get the correct date, I'm sorry. Okay, that's all the questions I have. Thank you, sir.
Good afternoon, sir. And you didn't witness anything, you didn't witness whatever brought you to that scene, correct?
No, I did not.
And you took Mr. Chapman into custody based on the word of whatever this counselor told you, correct?
Yes, ma'am.
All right, so you have no actual knowledge of what happened before you arrived there,
Well, I interviewed...
based on what you saw. You have no actual
The
knowledge.
only thing I saw was Mr. Connick restraining Mr. Chapman.
And you said Mr. Chapman was trying to get away.
He was trying to get loose, ma'am.
Okay, he was trying to get loose. But whatever caused you to arrest him, that was based on what you got that day from Mr. Connick.
Correct, and also from Mr. Chapman. Mr. Chapman told me that he...
Oh, hold on. I'm not asking you any of that, okay? I'm asking you about why you took him into custody, and the first thing you told me was the only reason you took him into custody was because of what Mr. Connick told you. Do you recall when you first said that?
I detained him for the safety of the other kids there and the staff and myself because of the altercation that was happening.
Okay, and by altercation, what you just described was you saw Mr. Connick on top of Mr. Chapman.
Correct, and also the information I was receiving over the radio.
Okay, all right, what you received over the radio, Mr. Connick on top of Mr. Chapman, and Mr. Chapman trying to get loose.
Correct.
Okay, thank you.
You didn't observe anything, right?
I'm sorry, sir.
You did not observe anything other than what you saw?
Not what started it, just when on my arrival.
Okay. You may step down.
Thank you, sir.
Let me ask you, hold on. Let me ask you this. You took out the petition, what happened? What's this position?
I'm sorry, sir. I couldn't...
What happened in court when you took out the petition? Was it resolved?
I didn't attend the court hearing. I know that he was found guilty.
You know that?
That's what I've heard.
That's what you heard?
Yes, sir.
You may step down.
Thank you.
Hold on, sorry, we're going to do
Judge, there's one other issue to address also, if I could. The court on Tuesday ordered the Commonwealth's attorney to provide to us the Virginia Department of Juvenile Justice offense history report with respect to Mr. Chapman, and that reflects that there are 4 findings of guilty, parents not innocent. The first was possession of a weapon on school property, September 20th, 2010, in the Portsmouth Juvenile Domestic Relations Court. The second was a finding of guilty, parents not innocent, of brandishing a firearm on school property, October 18th, 2010, in the Portsmouth Juvenile Domestic Relations Court. The third was a finding of guilty, parents not innocent, of threatening to bomb or burn a building on April 2nd, 2014, in the Portsmouth Juvenile Domestic Relations Court. And last was a finding of guilty, parents not innocent, of assault and battery on March 12th, 2013, in the Chesterfield County Juvenile Domestic Relations Court. So we'd be seeking to introduce those convictions or findings as well.
First of all, the Commonwealth has an objection to the testimony of Officer Tiller, who just appeared before the court. He has no actual knowledge of what transpired. He didn't attend court. He has no idea what happened. He also indicated that there was an offense date of April 14, 2014. There is nothing that has been indicated thus far that has resulted in a conviction or a finding of not innocent for Mr. Chapman that's come in up to this point. Mr. Broccoletti just indicated that there was a conviction for assault or a finding of not innocent for a juvenile on March 12, 2013. That's well before this incident that this gentleman just testified to. So we have no idea whether that was adjudicated or whatever the case may be, and he has no actual knowledge. So I would object to his testimony. And with respect to the other convictions that are on the juvenile history that was provided, with the exception of that last assault, there are no charges that are listed under 19.2-297, which indicates what types of offenses under the Virginia Code are considered violent. Just because the person was convicted with certain things doesn't make it relevant to this proceeding. It can only be instances where there's a turbulent, violent, or aggressive nature. And Your Honor, the criminal history being introduced is not the proper mechanism. I would object to a person's criminal history or juvenile offense history being introduced into evidence as improper evidence and as hearsay.
Judge, first of all, with respect to the definition of acts of violence, that's a specific statutory definition which is in relation to possession of a firearm by a convicted felon as to whether or not the prior conviction was a felony, and other various factors that are interrelated within the Code of Virginia as elements of offenses for either criminal charges or enhanced penalties as a result of prior records, or for bond. The court knows under 19.2-123, I believe it is, acts of violence defined in the bond statute cause...
The statute that actually defines what is crime or not.
Sir?
There's a statute that defines
Crimes of violence, but that, yes, but that relates only to other statutory constructions. It doesn't relate to violent, turbulent, or aggressive behavior under the laws of evidence. We're comparing apples and oranges.
and read those convictions again from the date.
Yes, sir. The first one was possession of a weapon on school property,
What date?
September 20th, 2010. The second was brandishing a firearm on school property, separate date, October 18th, 2010. Third one was threatening to bomb or burn a building, April 2nd, 2014. Last was assault and battery, March 12th, 2013.
What was the year again, the last one?
I'm sorry, sir?
What was the year again for the last one?
March 12th, 2013.
Now, first of all, the ones on 2010, I'm not going to go in. All right? The case has been decided recently by the court, a high court, within my discretion with respect to that. In that case, the act was probably about 3 years old, and the court did uphold the trial, indicating that the trial was put to bed, and they go back to a certain year. Now that the one is 3/12/13, again, you're going to charge again.
Assault and battery.
And you want me to allow you to introduce that to the jury?
I do, as well as the threatening to bomb a building in April of 2014.
What's your position? Let me see that. Last two.
Your Honor, I'm checking again and again, but I see a threaten to bomb 2010. I don't see 2014. So we would argue that Advent versus Commonwealth is not sufficiently connected, as the court just indicated, with respect to the other 2010 convictions. So we would object to that as well. We would renew our argument with respect to the 2013 conviction that this is not the appropriate way through this Virginia Department of Juvenile Justice offense history report to introduce that into evidence.
We're getting that for you, judges. Can we highlight it for the court? Or can we, sir?
I can read.
Okay, okay. We'll just tell you what page it's on.
Your Honor, while they're working on their documentation, I would just correct something that the gentleman said who was on the stand. He indicated that he believed the offense date, I believe, was April 14th of 2014 for the event that he described. On the Virginia report that we provided, there was a charge that transpired on April 13, 2014, which would seem to be the same thing, which was non prosequi. And so he indicated he believed he heard there was a conviction. It seems that this is the same incident, and it was non prosequi.
You hear that, Mr. Rockford?
Sir?
You hear what you just said?
I did, Your Honor. I don't think, even if the court allows his testimony, I don't think that he can opine that he was found guilty of the offense. I think that's clearly hearsay.
Well, it's hearsay about what he said. He did not observe this on now, did he?
He did not.
Based on what he was told.
Correct.
By the counsel and Mr. Chapman.
Right, and that's the problem, that we don't have the counselor because he won't show up. But he can certainly testify as to what he saw when he got there and what he did as a response to that, in terms of the actions of Mr. Chapman, the language or the verbalization of things between the two of them, and that as a result of what he saw and observed.
He saw Mr. Chapman trying to get away.
Correct, and the counselor on top of him.
Still waiting on you.
Yes, sir. I'm sorry, could you just give us a minute? I apologize.
Quiet in the courtroom.
So, Your Honor, and I apologize because the pages were the way they were printed out. The arson was April 2nd, 2012, not 2014. I apologize for that mistake. And the assault, the offense was November 15th, 2012. The adjudication was March 12th, 2013. And I have these 2 pages for the court. Yes, sir.
And notwithstanding what the officer testified to, it's appeared to be the same one, but it says it was non-props, right? Which means he wasn't found guilty.
That's correct, Your Honor.
And also, the officer was not present, but the main issue that he was found not guilty. That's not coming in. The ones from 2010 are not coming in, which leaves the assault and battery on 2013.
And there's also the arson, Your Honor.
I'm not going to do those at 2012. Mr. Chapman was born. What's the date of birth?
Your Honor, his date of birth is February 28th, 1997.
I've made a lot of rules in this case, and I told y'all yesterday, I want everybody to get a fair trial. I'm having that hearing that I heard, May 19th. That motion I heard. The last rule I made yesterday, the comment wanted to introduce some messages that the defendant, the conversation he had with the dispatcher. And the part that they wanted to introduce, some objected to by the defense. On 559, that would be AM, from Unit 151B, which would be the defendant's unit. He's calling, having a conversation with the dispatcher, it says, and he says, dispatcher said at 5:58 a.m. on the 22nd of April, hate your job, really? Then from 151B, which is the defendant's unit, said, I really do. And then the dispatcher says again, hate your job, really? And then it says, oh no, that's never good to be working a job you hate. This is from the dispatcher. And then the defendant responds back, saying too much bad and not enough good. Then the dispatcher responds, no, that's never good to be working a job you hate. She said, it's the city we work for. Then he responds back at 6:04 a.m. No, it's the whole world. The city sucks, but so does the rest of the world. People are just bad. I think the story was that God would have spared Sodom and Gomorrah if they could find, he says found, F-O-U-N-D, just 10 decent men. And he wound up smiting both cities. The special response is the city we work for. Now, notwithstanding that, and notwithstanding, because we're trying to say this, we indicate the state of mind before this incident took place, I ruled that I didn't want any side issue to be put to the jury, and I ruled that, notwithstanding how damaging it may be, that the prejudicial effect that it may have on the jury, without being exposed to that, I'm not going to let this in for the same reason. No exception.
No objection, Mr.
Okay.
Can we see if Mr. Childs is here?
You may.
Thank you, Your Honor.
Can we make, we think he is, just to be sure. And also, may I release Officer Tiller?
You may. That's your next witness?
Judge, Mr. Childs is present.
Hold on a second. I'm sworn as in front of the jury. Bring Mr. Rockland back. Something else I want. Go back out there. Also, Mr. Rockland,
Yes, sir.
another reason, I don't see any certification of these folks.
May I retrieve them, Your Honor?
That's another reason why I'm not glad again. I don't see any certification on the documents. Yeah, call the witness back. Bring the jury in.
Thank you, Your Honor. Brian Childs. Good afternoon, sir. Could you tell the jury your name?
My name is Brian Childs.
Mr. Childs, how are you employed?
I am employed by Taser International.
What exactly do you do with Taser International?
I am the Technical Compliance Manager.
What does that mean?
I actually have two jobs. As the Technical Compliance Manager, I'm in charge of our compliance with any technical regulations like the FCC or any European regulations with wireless technology. I also do investigations on weapons and cameras for customers.
I apologize, but spell your last name, please.
C-H-I-L-E-S.
Okay, thank you.
What type of training and experience do you have that ultimately led you to this position as the technical compliance manager, allowing you to deal with the technical regulations and ultimately investigations?
It was mostly on-the-job experience. I've been with Taser for 10 years and actually coming up on 11 years. I started our validation test team, and what that is we do all the testing on products, testing software, hardware, environmental, any type of testing to verify the product is working as it's supposed to.
Your Honor, at this time, I stipulate to Mr. Childs as an expert. I know Mr. Childs.
Judge, I would ask that he be received as an expert in Taser use, functionality, and analysis. Thank you. Mr. Childs, if you could, tell the ladies and gentlemen of the jury if you had an opportunity to look at the Taser that is one of the pieces of evidence in this case related to an incident back on April 22nd of 2015.
Yes, I did.
How did you come into possession of that Taser?
Virginia State Police sent it to Taser for analysis.
When was that?
I don't recall the date. I believe it was in September of 2015.
So you had an opportunity, you personally had an opportunity to examine the Taser?
Yes, I examined it, did the download, looked at the data.
Prior to doing the download and looking at the data on the actual Taser, did you do a physical examination of it?
Yes, I did.
And what, if anything, did you notice about the condition of the Taser?
The Taser itself, the Taser weapons are put together in halves, so there's a handle half, and then they're sonically welded together. On this Taser, at the bottom where the battery pack would go in, the handle half is separated, so it causes a loose connection.
Judge, may I approach to retrieve the Taser?
Counsel, y'all can do
Thank you, Your Honor. May I approach the witness?
Mr. Child, I want to show you what's been received in the witness. Commonwealth's Exhibit number 20. Specifically, I want you to look at the Taser. Is that the Taser that you actually examined?
Yes, it is.
And Judge, I would ask for permission at this point in time to allow Mr. Childs to come down in front of the jury to point out exactly what he was testifying to about the cracks.
You may step down.
And Judge, may I approach as well?
Your Honor, may I approach as well? Thank you.
Mr. Childs, you testified a moment ago that there were some cracks. I may not be using the right terminology in the Taser when you visually examined it. If you could point out for the jurors exactly what you were talking about.
Okay, this is the bottom where the battery pack or the camera plugs into, and the plastic right here is split. So this is usually a very tight connection. I don't know if you can see, I can kind of split it by putting some pressure on it.
Are there any other cracks in the Taser that you noticed?
There are some minor cracks you can see in the plastic up here. I wouldn't expect those to affect operation, but they were noted in my report.
Thank you.
Again, members of the jury, I apologize for that meeting. That was because they have a conflict to get ready for one.
Mr. Childs, what type of taser is this?
This is an X26 model Taser.
And when was that first manufactured?
2003 was when we first went into production.
Is that taser still in production?
No, we went, this one went obsolete, I believe it was January 2015.
What do you mean by obsolete?
We stopped making, and we only support the any weapons under warranty, but we stopped support on old weapons and stopped making them.
So you stopped making them in January of 2015, but still continued to have them out in the field amongst law enforcement?
Yes.
So there was no recommendation from Taser that the tasers, this X26 that was no longer going to be manufactured, be returned?
No.
They were still useful?
Yeah, if they're still useful, they can still be used.
Okay. Tell the jury, if you would, a little bit about how the taser works in conjunction with a taser camera.
Okay, so the basics is the taser, it's actually called a conducted electrical weapon used to incapacitate someone who's being combative. It's designed to lock up muscles. It's not an electrocution. It's we actually override the central nervous system. So when fired with the darts, and the darts are placed with enough muscle between the probes, the body's muscles will lock up involuntarily. And when the trigger is pulled, it'll run for an automatic 5 seconds, and then it shuts off. Now, when combined with the Taser cam, which is the camera, the Taser cam supplies power to the weapon and also records the incident in black and white video. When the weapon is armed, so when the safety is placed in position, the weapon is ready to fire, the camera will begin a boot up process. After approximately 2 seconds, between 2 and 3 seconds, the camera will boot up and start recording automatically.
How is it that you turn on a taser?
There's a, the tape is covering it. Oh. There's an ambidextrous safety on the side, so usually with the thumb, you can flip it up to arm it and flip it down to turn it off.
And when you say an ambidextrous safety, there's a safety that can be activated on either side of the weapon?
Yeah, both sides have the lever, so
it can be utilized by
or right-handed.
left or right-handed. And just to be clear, you indicated it takes 2 to 3 seconds for the taser camera to boot up. So when that safety is activated, can the taser be used?
Yes, the taser will operate immediately when the safety is put up. The trigger can be pulled and it'll deploy.
You testified just briefly about the purpose of it, how a taser works in conjunction with the taser cam, and you talked a little bit about the probes. If you could tell the jury the 2 uses of the taser.
So a taser can be used in 2 different modes. There's typically called probe mode, and that's where there's a cartridge that fits onto the taser, onto the front. That cartridge contains wires that are tethered to 2 darts. The first arc, the first electrical arc that comes out of the taser ignites a primer in the cartridge, and that it builds up pressure from the primer and pushes what we call a gas capsule. It has compressed nitrogen in it. That will push that into a, the word's escaping me. Well, it'll get punctured. The air comes out and pushes the darts downstream. So that launches the darts. And the probes, your goal is to hit the subject and have the muscles lock up. There's another mode called drive stun. That's where the cartridge can be removed. Or if it's a shot and miss with the taser, they can come in and drive stun, or it's also called touch stun. But you have to make contact with the individual, and that causes a painful response.
So what is the purpose of the drive stun?
Drive stun is mostly for pain compliance.
And you indicated you use the drive stun either by removing the cartridge on the end of the taser or what?
You can have the cartridge still installed and touch someone with the front of the cartridge as well.
The front of the cartridge.
Yeah, you don't have to remove the cartridge to do it.
After the probes are shot out in a situation, can that cartridge be reused?
No, cartridge is a one-time use.
Did you come into possession of any cartridges as it relates to this particular case?
Cartridges were shipped with the device, yes.
And did you look at them?
No, I did not.
Judge, if I could have one moment. As it relates to the taser camera, how does that store information?
The taser camera has onboard memory on the circuit board, and the videos are recorded, compressed, and stored on the memory on the taser camera.
Once a video is captured and stored on that taser camera, is there a way to manually delete any videos?
No, you can't delete videos off the taser camera. We only allow access to download.
On this particular case, you had an opportunity to examine the videos that were on the taser cam, correct?
That's correct.
And focus specifically on the date of April 22nd of 2015?
That's correct.
And in looking at those videos, were you able to determine if there was any possibility that there was deleted segment?
No, well, yes, I did look at it.
And what did you conclude?
I conclude there are no missing videos. Each video is, when it's created with a sequence number, and that number is just incremented by 1 for every video created. And all the videos for this incident were congruent.
And in examining the taser camera in this particular case and looking at the videos, well, let me back up. You actually watched the videos, correct?
Yes, I did.
And there was a period of time, would you agree, that there's 15 seconds that there's no recording?
That's correct.
How could that be?
So that can happen if when the taser cam is disconnected from the X26, it will stop recording. So as I pointed out, there is a crack in the plastic. I was able to run a test and put pressure on the taser cam and get it to disconnect. If that happens in the field, it's going to stop recording, and then when it reconnects, it's going to boot back up and start recording again.
A blow to the taser, if it's thrown or lands on the pavement, could that cause any issues?
Yes, it could.
Like what?
It could cause the separation in the plastic, or if the plastic is already separated at that time, it could cause a disconnect between the taser cam and the taser.
Any other reasons for why there could be 15 seconds of no video?
The only
Object
other
to any
reason
speculation.
Judge, he's been qualified as an
The only other reason there would be no video in between is if the weapon was shut off and then turned back on.
At Taser, you all have a manual that you send to police departments on how to use the Taser, correct?
Yes.
And Are there general concepts about caring for the taser and how to maintain the taser?
I believe so. I haven't read the manual in a while, but I believe so.
Specifically, tell the jury, if you would, what it means to spark test a taser.
Spark test is when we recommend a spark test every day or before each shift, and that is to turn on the weapon and check the laser and flashlight, make sure they're working, and then fire the weapon and make sure that it's operating before you go out on shift.
And is that recorded or documented in any way when there is a spark test?
It can be, yeah. Most of the time it can be. There is situations where it wouldn't be.
How is it documented?
Well, it's documented in the, okay, so I didn't explain, in the weapon, there is also a memory chip on the circuit board, and we record what I call activation data, or also called firing logs or event logs. You might hear all those terms. And that is a sequence number, the timestamp, duration of the activation, temperature of the microprocessor, and battery percentage remaining. All that gets recorded. And then also the Taser cam could record video of it.
In looking at a report that is generated showing trigger activations, is there a way to determine whether it was a spark test or used in some other way?
No, you can't tell.
Are the trigger activations and the videos that are recorded on the Taser camera, are they date and time stamped?
Yes, they are.
And do they have separate mechanisms to record the date and time, or are they all one?
Well, for recording it's separate, but getting the time is held on the microprocessor in the X26 weapon. The camera will ping the weapon and get the current time from the weapon. So the camera doesn't really have a clock inside of it.
So what is expected is the date and time that is on the video will correspond with, if there's a trigger pull, correspond with the date and time of that trigger activation on the report.
That's correct.
In conducting your examination, you had an opportunity to review a report that was generated by the Department of Forensic Science.
Yes.
Specifically an event log from Evidence Sync.
Yes, I believe it said item 19 on it.
Your Honor, may I approach the witness?
I'm going to show you a document. Do you recognize that document?
Yes, I do.
And what is that?
This is the activation log from the X26.
And this activation log, is this what you generated, or was this what you were provided?
I was provided that by Virginia State Police because I had trouble downloading the weapon.
What do you mean you had trouble?
At first, I made a couple attempts to download the weapon, and it would not download. I was getting errors. Then I went to a engineering software that we have. So our software tries to read the serial number of the weapon before it does the download. And I'm speaking of our customer version of the software. When it can't read the serial number or there's an error there, it doesn't do the download. So I used engineering software that doesn't even look at the serial number, just got the data, and I was able to download it that way. And it turned out the serial number was correct, as well as the firing data.
The serial number and the firing data was corrupt, you said?
Yes, data corruption.
What do you mean by corrupt? Do you mean altered in any way?
Not in an intentional sense. I'm not saying altered in that way, but the data has changed from its original format. It's corruption. Data corruption can happen, microprocessor error, or could be noise, or something causes it to change.
Could it be could it be manually altered or changed?
No.
And in reviewing the event log provided to you by the Department of Forensic Science, you had an opportunity to review specifically the trigger activations on April 22nd of 2015.
That's correct.
And I will be happy to show you this document again if you need it to refresh your recollection. But do you recall that there are 2 trigger activations in Eastern Daylight Time that would be 7:35 a.m. and 52 seconds and 7:35 a.m. and 57 seconds?
Yes, that's correct.
And they're each 1 second in duration.
That's correct.
You indicated earlier that when a trigger is pulled, the taser activates for 5 seconds.
That's correct.
So what would cause the 1 second duration in a report?
A 1 second duration would either be caused by the safety being placed down, turning the weapon off, or a battery disconnect.
And you obviously don't know what caused this issue.
Yeah, I can't know for sure.
When the trigger is pulled and a taser is activated, let's talk drive stun mode, is there a distinct sound that it makes?
Well, regardless of the mode, it's what you hear with the taser is the arcing. It's the electrical arc. Typically in drive stun, you are arcing from one electrode to the other, which is the maximum distance, and that is a loud crackling sound. When it's connected to a load or to flesh, it's not arcing anymore. It doesn't have to jump through the air anymore, so the sound goes quiet, more of a ticking sound.
In your review of the videos recovered from this particular taser, did you hear the taser going off or the crackling?
In the first video that was recorded at the very end, there is a sound, but I couldn't definitively say that is the taser because there's a lot of noise as well, a lot of non-taser noise as well. So I can't definitively say if it was the taser or some other sound.
Judge, may I have a moment to plug in the laptop? Mr. Childs, if I could ask you to step down. And in just a moment, I'm going to press play on one of these videos. I want you to focus on the date and time stamp, and then we'll talk a bit more. Did you get a good look at the timestamp?
Yeah.
You can go ahead and have a seat.
It appeared that the date and timestamp, let's talk just about the timestamp. It said 11, let me make sure I don't mess this up. It said 11:35 and 39 seconds when it started,
Yes,
and 11:35 and 50 seconds when it ended.
that's correct.
And what does that translate into in our time?
So in the weapon, the clock is set to Greenwich Mean Time, GMT, and that is that's pretty much the universal time constant that people use, or that software uses. And then it's converted to local time, I believe, with daylight savings, it's GMT minus 4 hours.
Okay, so you would expect that you indicated that obviously the video said 11:35 and 39 seconds through 50 seconds. So if we subtract 4 hours from that, that is our time on the East Coast.
That's correct.
So 7:35 a.m.
That's correct.
Having seen the video and looked at the log received by you from the Department of Forensic Science, there appears to be trigger pulls after this video.
Object to leave.
Correct? Judge, I'm just directing him to the portion of the log that I need to question about.
I've been around both of y'all to leave.
There's trigger pulls based on this.
I haven't said anything, so we can keep on going.
Thank you. Turning your attention back to the April 22nd log. You testified earlier that there were 2 trigger pulls that were 1 second in duration.
Correct.
But they do not seem to be depicted in the videos. Can you explain why that is?
Well, for one reason, I want to make it clear, the time in the log that you see is at the end of the cycle. And so I believe the log recorded the first one at 7:35 and 52 seconds, which means the trigger would have been pulled at 7:35 and 51 seconds. And we have to kind of plus minus 1 second here.
Okay. So again, why would that, you indicated earlier about how the Taser camera works. Why would those trigger pulls not be on the video?
I believe it could be a battery disconnect. And I don't mean just the battery disconnect. I don't know if you can see when I showed over there, but there are 6 battery contacts. 3 are for power and 3 are for data. So if one of the data lines were to disconnect, the camera would turn off, but power would remain on the weapon.
In reviewing the videos that you retrieved off of the Taser camera in this particular case, did you notice any discrepancies in the video and the audio?
Yes, I did.
Tell the jury, if you would, about that.
In I believe the second, third, and fourth videos, I noticed audio lag, and that's where something happens in the video, and then you hear it happen a few seconds later.
What causes that?
It's a software error. My guess on this one is because the logs were corrupt, the serial number was corrupt. If you notice in the video, on the watermark in the video, we display the time on the bottom. On the other side, on the bottom, we display the serial number, and the camera had to display X00000000 because it couldn't read what the serial number was in the software because it was corrupt. So I believe all of this confusion with the corrupt data caused a lag in the processing of the video and audio put together.
And again, when you say corruption, we're talking digital corruption.
Yeah, just data corruption.
Any of what you testified to about the corruption, can that be altered manually?
No.
Going back to the report again that was provided to you by the Department of Forensic Science, you indicated that this particular taser was first produced in 2003, correct? The X26?
2000, the X26 model.
Yes,
Yeah,
the
not this
X26
particular
model.
taser. Right.
And do you know when this particular taser was produced?
I might have put in my report, but I don't recall.
And again, I will show you the report if necessary, but there appear to be in the report provided to you from the Department of Forensic Science dates prior to 2003, and then for specifically September 10th, 2000, where a trigger was activated for 192 seconds. Is that accurate?
No, in the download that was conducted by Virginia State Police had shown signs of corruption as well. Even in that download, the serial number was already corrupt, and that had become corrupted as well.
So can we be certain that the dates or the times on April 22nd on the report are accurate?
They appear to be.
What do you mean by that?
They are a valid, there's a lot of valid date and time stamps that are consecutive with each other. They don't go back and forth. If they were back and forth, I would suspect corruption. So that's why I mean they appear to be valid.
How is the date and time in the actual taser set?
It is set in the factory to Greenwich Mean Time at the current time that when it's manufactured, and it goes through a process called kitting, and that's where they set the time and delete any test firing records in the weapon and prep it for shipping. So the time is set at that point.
Is there any way to manually change that time after that point?
Manually change it? No. Well, there's software that we allow a synchronization of the time, and that initiates a time change, but you're not manually, the software does it.
Could an officer take the actual taser and change the time or date on it?
If he has the software, yes.
But in his hand, without the software?
No.
Okay. And when you say synchronize, what do you mean by that?
Every clock in the world has an amount of drift to it, and the X26 is no exception. The clock will drift a certain amount over time, and so we suggest like once a quarter they download the weapon and connect it to the software and set the clock to the computer's time. That's what the software does, is it'll synchronize the clock to the computer's time.
And finally, based on your review of the videos that were retrieved off of this particular taser, is there any indication to you that it is incomplete? That the videos contained are less than what was included on the actual taser?
I believe that there was some battery disconnect and the camera shut off during the incident. I believe it turned back on, and the end of the second video, I believe, now the taser cam will record, if you leave it on, it will record in 10-minute increments. So meaning it'll record for 10 minutes, close that video, start a new one immediately, and continue recording. The X26 will, without activity, it'll stay powered on for 20 minutes. And in this case, it recorded for I believe 6 minutes, a little over 6 minutes, and it turned off and then the camera turned off and turned back on, I believe 9 seconds later. So that to me indicates that maybe a battery disconnect or something happened, the video stopped and started back up again 9 seconds later.
But what was actually captured by the Taser camera on April 22nd, is that everything that you were able to download?
Yes, it is.
And everything that was in the videos that we've been talking about?
Yes.
Thank you. I don't have any other questions.
Counsel. Counsel. The exhibit.
Your Honor, may I approach the clerk?
Counsel Cumberland.
Thank you, Your Honor. Good afternoon, Mr. Childs, all the way from Arizona. Okay. So let's talk a little bit about your software.
Yes.
So there's proprietary software, and then you have engineering software, right?
That's correct.
Okay, and so the agencies that buy tasers from your company, do they in turn get that proprietary software so they can download and do different things with the taser footage?
Yes, they can download it off our website as well.
Okay, so Portsmouth Police Department is an agency that carries your tasers, and they have that software. Well, you don't know. You don't know whether they have it, but you said they should.
Yes.
Okay.
We make it available to them.
Okay, so it's made available to the agencies, the law enforcement agencies that have your devices?
Yes.
Okay. And you indicated that there are 2 different ways that you can tase somebody. And one way is drive stun, and the other way is with the leads.
Right.
What's that called? With the leads, what do we call that?
They call it probe mode.
Probe mode, okay.
Cartridge mode.
Cartridge mode, okay. So probe mode shuts down the central nervous system and locks up the muscles, right?
Yeah.
Okay. And drive stun is for pain compliance.
That's correct.
All right. And so why is that? Is that releasing a higher level of voltage than probe mode? Explain to us why that's pain compliance and the other one is muscle compliance.
Okay. Now, in both of these modes, the weapon doesn't change one bit. It's just how you're using it. So for probe mode, the electricity from the taser, the pulses, are delivered through wires from the cartridge into the probes. And if connected to the person, and if there is enough muscle mass between the 2 probes, it will send signals into the body, those pulses, overriding the central nervous system, and the muscles will think that the brain is saying contract, and so the muscles contract. Now, the contraction, how many muscles in the body contract, is dependent on how much spread is between those probes.
Okay. Sorry. Keep going.
So if you have less than approximately 9 to 12 inches of spread, you don't get the muscle lockup response, but it does cause pain. The conducted electrical weapon, it hurts no matter what. It's just when you have less spread, it only hurts. But if you have more spread, your muscles lock up and it hurts. I think you don't notice the pain as much because what happened to my muscles?
Right, and that's probe mode.
That's probe mode.
When we talk about drive stun.
In drive stun, you don't have the muscle lockup, but you do have the sensory pain.
All right, and is that sensory pain in drive stun more significant than in probe mode?
No, I believe it's the same.
It's about the same.
It's the same amount of pain.
Okay.
You just have a different response.
Now tell me about distance. What can I do with probe mode that I can't do with drive stun distance-wise from a person?
So with drive stun, you have to touch the person. You have to be close to the person to do drive stun. With the probes, they can, we have different lengths of cartridges, but say for instance, if you have a 25-foot cartridge, you can shoot from 25 feet away.
Do we know how many feet away this cartridge can shoot?
I'm not sure what cartridge was used in this.
Not too sure. Okay. Do you have a standard amount? What's the minimum amount of space that you can have that it can go, amount of distance? What's the lowest amount of distance that you have in your tasers?
We have a 15-foot cartridge is the lowest.
Okay, where is that from you? I know you said 15 feet for the record, but if there's anybody like me who's bad with distance, where in the courtroom, how far away is that?
About me to you.
Me and you?
Yeah.
Okay, so you could tase me right now.
Okay.
In probe mode, all right. So we now understand that in probe mode, we've got at minimum 15 feet. But drive stun, you would actually have to walk up to me and make contact with me, right?
That's correct. And let me clarify a little bit. The lowest cartridge distance that we sell is a 15-foot, but I could stand 5 feet away from you and deploy a cartridge.
Right. So you can be closer, but at the very low end, if we're as far apart as we can be, on the lowest end, it would be 15 feet, and then it goes up from there, right?
That's correct.
Okay. Now, let's talk about turning the camera on and off. So we can turn it on by arming it, right?
By arming the weapon.
By arming the weapon. And then there are two ways to turn it off. And you've established that those ways are either to unarm it,
Correct.
right? Or by battery disconnect.
That's correct.
Okay. And in this case, this particular taser, you said it has a crack, and you performed testing on it and squeezed it, and that caused the battery disconnect.
That's correct.
Okay. And so if we have a gap on this between recordings, either it's going to be, that gap is going to be because it was unarmed or there was a battery disconnect.
That's correct.
Okay. Thank you, sir. I don't have anything further.
Just a brief follow-up. Mr. Childs, when using the taser probes, and the probes are shot out of the taser, what typically, in layman's terms, happens to the person that is hit with the probes?
In layman's terms, their muscles lock up and they would fall over.
Okay. When using the taser in drive stun mode, would their muscles lock up and they fall over?
No. In drive stun, there's no lockup. It's just pain.
Thank you. I don't have any other questions.
Just one, Your Honor. So the sole purpose of drive stun, that's pure pain compliance?
That's correct.
Okay, thank you, sir.
Nothing further, Your Honor.
All right. Want to be excused?
Yes, I'd ask that.
Can you be excused?
Yes, sir.
You're excused.
Is that fly back home?
You can go home.
All right.
Take the airplane though.
I think that's as far as we can go today, Your Honor.
Members of the jury, we want you to reset for the day, okay? All of the instructions that I've been giving you, they still apply, all right? What do you say? No, it's it.
No, and you move by them again.
Okay, okay. Everybody remembers except him, right? All right. Again, there's print media and broadcast media here. And it may be something on the television, on the news, maybe something in the newspaper, maybe something on the radio. So I'm asking you again not to look at the news, not even CNN, MSNBC, no news, okay? And if it happens that you cannot read, and don't read the news. It may be hard and difficult for some of them, because you talk about 3 days. Do not go on the internet, do not go on any social media to see anything, learn anything about this case. Do not look up legal terms. And as to the radio, if you hear anything on the radio about this case, turn to another station. If you happen to inadvertently see something on the television, turn to another section, all right? I'm quite sure most of y'all should have remote controls by there. All right, I'm talking only one in the court that doesn't have remote control. But turn to another section, not read the newspaper. On the whole weekend, you may come into contact with someone that you may know. They may see something on the TV about this case. They may read something about it. They may ask you, just tell you a performance, excuse me, your civic duty, but you cannot discuss anything about this case. Same with as your family members. Advise them the same thing. And you need not call the tape. If you call the tape will indicate that no jurors are needed. That's not for you. I'm telling you now, report back Monday morning at 9:30 a.m. to this courtroom, to this jury room, okay? Again, don't call the tape. If you make a mistake, disregard the instruction on the tape. You got it? Okay. Have a good weekend. Take care of yourself. We'll see you early, 9:30 Monday morning. You can leave all your bags in the room, okay? In your bag is right there. Have a good weekend. Well, maybe see.
Your Honor, I have a brief motion. At this time, I would move for disclosure of the defense's expert, their report. They've subpoenaed someone who purportedly would be an expert. We did not receive a report in reciprocal discovery at this time. We would move for disclosure of that report.
Judge, Rule 3A11 does not provide for the disclosure of an expert's report unless there's scientific examinations, et cetera, et cetera, et cetera. This expert has not performed any scientific examinations and has not authored a report in any event, so therefore it would not be discoverable.
Motion, man. Based on representation of counsel. Now, you recall how many witnesses Monday?
6, 7, 8. 8, hopefully.
8, hopefully. What's the name of the witness that you want me to issue show cause?
Judge, his name is Mr. Jarees Comic. First name is Jarees. Last name is Comic, Commock.
She needs an address.
Yes, Judge.
And Your Honor, I understand that they are requesting a show cause because he did not come due to and follow the subpoenas requirements. However, Your Honor, the court has already ruled that the information pertaining to that incident is inadmissible, and I would, although I know I don't represent this individual, I would oppose that motion for show cause on that basis.
Well, it's still with it. Issue this opinion.
I understand now.
I would afford you the same case. They want to issue show cause on the issue. What's the address?
It's 3812 Summers, Summers, Trace Drive, Chesterfield, 23837.
Plus, no one should disregard.
Thank you, Your Honor.
Anything else?
No, Your Honor, thank you.
Not from the Commonwealth, Your Honor.
All right. I want you to report 9:15, okay?
Yes, sir.
Yes, sir.
All right. After the show call, what's the time that
How long does it normally take the court to? 2 weeks?
Stop, okay. Give them 30 days.
30 days, yes, sir.
Court is adjourned.